to talk about in the marriage, divorce, dating world, and we've got information for you as always. So we wanted to get right into it, and we're going to start with we've got an interesting story to talk about, and of course, who's not talking about Travis Kelsey, and Taylor Swift.
Travis and Kelsey and Taylor Swift.
And Travis and Kelsey and Taylor, as Rahul said before the show, kill a Trav.
Kill a Trav at Instagram.
On Instagram, which probably was a handle he gave himself in high school. But yeah, kill a Trav. So what do we got for you today? We've got all the scoop. And also the twist, everybody's talking about this, and unless you're living under a rock, you heard that they got engaged. So that's not the news we're here to talk about. We're going to talk about what would we recommend to them if they came to us as their lawyers and told us they were engaged. So we'll go through that. But first, some fun facts about this. First of all, we got the scoop that they were engaged like a couple weeks ago. Travis asked Taylor's father, Scott Swift, awesome name, for her hand in marriage, apparently, which is a class act for a first marriage. I think it's her first marriage, right? And his?
Yes.
They're both 35. Okay.
Mm-hmm.
He said in this story from People Magazine, link will be in the notes. Ed, this is Travis's father, Ed, said he'd been pressing Travis to propose to Taylor. By the way, dated 2 years. Following I Just Want This Done podcast marriage rules, which we've set some rules here. No destination wedding. No.
Mm-hmm.
Now they're breaking a couple rules here. They have a gigantic ring, which we'll get to in a minute. We're not sure about the destination wedding problem. But the rule was getting close to the danger zone with the 2-year dating. So they're dating for 2 years, and that's getting a little bit long in the tooth, especially for people in this age range. Not throwing any shade, as the kids say, but hey.
Now they're engaged. So
they're engaged. So there you go. But
good.
2 years is getting there. 1 to 2 years is about it. So anyway, those are the I Just Want This Done dating rules, which you should probably publish somewhere or put in the notes. So in any event, they got engaged, and I guess Travis got permission from and some advice from his future father-in-law, proposed to Taylor in his garden, and popped the question at home a couple weeks ago. Okay. So hilariously, we find out the wedding ring is this giant, it's enormous. And you can look it up online. And I think it's in one of these stories we're posting, but it's huge. And the estimates are that it's between $500,000 and $5 million. So one of our rules, one of our pet engagement rules we like on our show is, if you get the super ostentatious ring, that's a weak sign. That's not a good sign. If it's true love, you could give her some twisted wire or one of those candy rings, and she'll say
ring pop.
Yeah, the ring pop. Thank you. Ring pop. TM. By the way, ring pop, if you want to sponsor the show, we will accept a lifetime supply of ring pops. But yeah, she will take a ring pop and be happy. So $500,000 to $5 million, when she could probably buy 5 of those herself, cash, is maybe, I think it's like a sign of weakness, but maybe I'm not one of these like alpha male, characters on social media, but it seems like too much. But that's me talking. That's my personal opinion. Okay, the other thing to know is exciting to know, Flava Flav is offering to officiate the wedding. I'm sure they're thrilled, but I God only knows how they uncovered or Flava, he's listed as Flavor Flav, not Flava. Sorry,
Flava.
One of my former law partners referred to him one time as Clocky Clock when he couldn't remember his name. So, and I knew exactly who he was talking about. So he said he's happy for their engagement. And he calls the pop star his girl and the Kansas City Chiefs tight end his boy. Well, that's nice of him. And he said he's willing to be the officiant wherever they decide to tie the knot. Here's his quote: "I can't wait for the wedding. Let your boy Flavor Flav be the officiator. I would love to officiate the wedding." Anyway, I'd like to see that. I don't know. So they got that going for
I think that would be interesting.
Yeah.
That would make for a good Super Bowl halftime show.
Yeah.
But inevitably, the NFL stages the Taylor Swift Travis Kelce wedding at
Do you-
halftime.
Do you think the NFL? Okay, so a couple questions for the audience. Do you think the entire wedding is an arranged marriage put forth by the NFL? And that's one question. I'm saying this tongue in cheek. Secondly, do you want to see this happen at halftime at the Super Bowl? And by the way, Rahul, do you know enough about football to say, are they estimated to have good chances at making it to the Super Bowl? I wouldn't know.
Yeah. I do know enough, and I know enough to know that Patrick Mahomes will always have a shot at making it to the Super Bowl, just like Tom Brady did.
Okay.
Who is the undisputable GOAT of quarterbacks. But
Yeah.
I think Mahomes, as long as you have Mahomes and Andy Reid, who is the coach for Travis Kelce and Mahomes, I think they will always have a shot to make the Super Bowl.
So there you go. That's what we're talking about. So maybe we could get that halftime wedding and with Flava Flav officiating, which would be amazing.
Yeah.
So let's talk about.
Oh no, but real quick on that topic
Yeah,
though, it's
please.
like the war of the rings, right? Because a few weeks ago, what were we talking about right before was Cristiano Ronaldo, another athlete.
Oh, thank you. Yes, we were
got engaged.
Thank you.
And his Kinder egg of an engagement ring, as you put it, on his fiance's for his fiance. Now, how is that compared to what Taylor Swift received?
It's much larger. I have to tell you, it looks huge.
Cristiano Ronaldo is also probably much wealthier than Travis Kelce, given his Saudi oil money that he has over in the Middle East.
Yeah, and despite the fact that we love our football here, soccer internationally is monster sport, and the money is totally insane. It's kind of like we don't appreciate two things: Formula One and football the way they do in the rest of the world. So it's huge. But so that ring was giant. And then we also found out that Bezos's ring that he got Lauren Sanchez, now Bezos, was somewhat smaller. So I think there may be some ring envy going on with. So it's pretty funny. Anyway, Ronaldo seems to have won the prize of late with giant engagement rings. So thank you for bringing that up, because we wanted to talk about that. I appreciate it.
Yeah.
So let's go on. The one thing I want to talk about, the legal side of this, is we wanted to discuss what we would do if either of them came to consult with us for their prenup. And by the way, the phone lines are open. Operators are standing by. If Travis, if you're listening, or Taylor, your crew is listening, we are more than willing to consult with you. So just give us a ringy dingy, and whoever calls first, we'll talk with you. The other person, there's going to be a conflict. So we can give you great referrals though, if for the other person. So we'd be happy to talk to you about doing that prenup. And so Rahul, would you say in your estimation, we don't know a lot about these guys, but let's assume I'm willing to bet Taylor is worth a lot more than Travis is.
Well, she's a billionaire.
She's a billionaire. Yeah. She's a master business person. She's absolutely monster in terms of business and finance. And Travis has made a lot of money himself.
Sure. Yeah.
In the NFL. So what are your thoughts just initially at how you might structure this, or what you recommend to them in terms of a prenup? And do you think this is actually a complex prenup, or a actually fairly simple prenup?
I think it's actually going to be a very simple prenup, where really, it's what did Taylor Swift say when she posted the caption? Your English teacher and your gym teacher are getting engaged or something, or getting married or something like that. So it's like they're clearly doing this because they like each other, not for any sort of a financial gain. I mean,
right.
You would give Travis different advice than you would give Taylor, but ultimately, I think generally this would be a very simple prenup, and it would be something where I would believe it is that depending on if they live in a community property state or equitable division state, it's sort of like you each keep what you have, you each keep what you earn.
Right.
And if you guys create any sort of what you would define as, joint property or community property or marital property, whatever you want to call it, let's say, then you would probably either split that equally, or you would split that in proportion to what each one of you put into it. So let's say they buy a house together in, I don't know, where is she from? Texas or Georgia. I don't know,
Yeah.
or let's say in Missouri,
Sure.
where Kansas City, Missouri. So it's like they buy a $5 million house, and she puts down $4 million for the five, and he puts down $1 million. So they either split that, where each get 2.5 if they get divorced, or she gets her 4, she gets 80%, he gets 20%, right? Based on the amount of contributions. So that's kind of what I think. Apart from that, obviously, neither one's going to get any sort of spousal maintenance or anything like that from the other person. They're both well off, and I don't think either person's going to really. Well, definitely Taylor Swift won't, but I don't think Travis Kelce will either. And
Yeah.
so I think it should be a very straightforward, simple prenup. And the rule with prenups is you want it to be as simple as possible. You
That's
don't
right.
want it to be complex, because the more complex it is, the more interpretation issues you might have, and
Yes.
the more complicated the enforcement is. So you want a super simple prenup to make it as effective as possible, which I think is what they'll do. And we know we always talk about how rock solid prenups are if it's done right.
Yeah, I agree 100%. This is, you really can't emphasize this enough, because we have a case right now involving a prenup, and it was drafted by a non-divorce firm, but a very reputable big law shop. And it is an overblown, overly complex document. And it has what I'm sure the drafter thought were clever definitions of what we would call marital property and how that would be addressed. The problem is it overdefines it and slices it thinner than it should be. Right to your point, that the problem in the case that they've been struggling with now for 2 years is the definition. Essentially, it was an each keep own prenup, which, like you're describing, basically you bring your stuff to the table, that's yours. The stuff I bring to the table remains mine. And then there are certain things that are ours jointly. And if you keep it really simple, it's very clear for lawyers and judges to understand later in a divorce what to do. But this has some very subtle definitions that are sort of open to interpretation that have caused all kinds of trouble in this case. And I'm glad to say we didn't draft it. We're just helping one of the people with the resulting divorce case. But it's causing a tremendous amount of headaches and expense. So it's exactly what you're saying. The simpler the prenup, the better for everybody. And the only piece that I could see as being complex is the disclosures, meaning both of them showing each other their income and assets and expenses and their liability, whatever their debts are. And because you really want full disclosure. Other than that, the prenup is really more than likely, like you said, it's you keep your stuff, I keep my stuff. If we create things together, we have to do it intentionally. So we change the definition of marital property to that it's not a default marital property thing. And yeah, you're absolutely right. So that's what we would recommend in this case, is keeping it very simple and elegant to protect them both in the event of a divorce. They're both fine without each other. So we don't really need to, you're right, that Travis, okay, he makes less than she does. The advice might be something different, but generally speaking, he's going to go on just fine if they were divorced, and she will too. So
right,
it's really just what we'd call a walk away would be
right,
the,
exactly.
like, be the best thing. So
right. And they
that
both,
gives you a little,
yeah.
That gives you a little inside view here. And we've talked about on previous shows, the imbalance of power in a relationship causing the strife in preparing prenups. These are easy when you have two people that both have more money than they're going to need in their lifetimes. There's really no issue here. And this each keep own prenup, that's simple stuff.
Right.
So,
And we at our firm have obviously worked on some very ultra high net worth individual prenups, prenups for prenups that involve athletes, etc. And so we kind of know the considerations that go into this, and we know how they think to a certain
Right.
extent. We know how their team thinks, and the disclosures, like you said, will be complex, understandably so. But they also have accountants who will just delegate, that'll be delegated to. So it's not like Killer Travis sitting down writing down what he's got. And he actually might surprise people, because his income is from being an athlete primarily, but I think he's got a bigger scope, sort of like his brother, with the New Heights podcast that they have that I
Okay.
think is exploding. And then he's on a ton of commercials. And
Sure.
so I think
Endorsements,
his
stuff like that.
endorsements, et cetera.
Right.
So I think his only source of income is not just income from his NFL career. So I think he'll be just fine, like you said.
Yeah. So those are our thoughts on this one. And this one, like these big ones, are kind of in some ways easier. Like, is it more
Mhm.
complex from a disclosure standpoint, but from the legal standpoint, not too tough. And remember, folks, you can't do anything about kids in a prenup. Your future children, you can't deal with child support. You can't deal with parenting. You can't plan all that stuff out in a prenup. It's all financial. So,
Right.
just to give you a little orientation on that. So, okay, turning us more celebrity news. Tell us about French Montana, who I hadn't heard French Montana in a while until we came up with this story. What's up with this?
Yeah, he's been, I guess, jet setting in the Middle East and Europe, I guess. So French Montana just confirmed his engagement to Dubai princess Sheikha Mara Mohammed Rashid Al Maktoum.
Easy for you to say.
Yeah, right. It's just that's just her name, simple name. And they were first, I guess, linked in October of 2024 during the Paris Fashion Week. And he's known for his French Montana is obviously a rapper who is known for, I think, the song "Unforgettable," but I think that's
Okay.
about it.
Not to be confused with Hannah Montana.
Not to be confused with Hannah Montana, exactly, who also happens to be a music star now. So, French, as they call him in this article on E Online, popped the question to who's 40, popped the question to Sheikh Amara, 31, during Paris Fashion Week in June, shortly after he walked the runway for the first time. And then she is the daughter of Sheikh Mohammed bin Rashid Al Maktoum, who's the ruler of Dubai. So you can imagine the prenup again that'll go into that one. And she was previously married to her husband, Sheikh Mana bin Mohammed bin Rashid bin Mana Al Maktoum, although she announced their split in July of 2024. And it was done with one of those it was done in an Islamic divorce fashion, where I believe it was on
triple
Instagram.
talaq.
The
Yeah,
triple
that's right.
talaq, where they
Yep.
did it on Instagram. And so, you talked about it before before the pod here. We've dealt with a lot of those kind of cases, which
That's
is
right.
and like you said, the triple talaq is a law practice allowing Muslim men to divorce their wives by simply saying it 3 times. But
It's not. It's legal.
yeah,
It's
it's not
only
legally. Yeah,
binding for men under
right.
Islamic law, which is interesting, and that's the
Mhm.
tradition. For women, they can't do it legally, but she has to go through more of a process. But
Right.
it's kind of going public about the fact that you're breaking up at the very least.
Right. And you're kind of putting it out there. So
Right.
that's interesting. We'll see what happens. I'm sure that's going to be one of our, Indian Ambani wedding type things when that does eventually happen, because just like the Indians, just like the Indians, the Middle Easterners love to have a big wedding.
It's going to be a big party, I'm sure. So interesting, and we'll keep. And he's actually Moroccan, I believe.
Yeah, he is. He is Moroccan.
I didn't know before. Okay. Well, no, that's interesting. So we'll keep our eyes on that one. And there's going to be a prenup there. There's no question about it.
Oh, absolutely.
Or whatever similar document they do in that part of the world. We have seen in our cases, and unfortunately I don't recall the name. I should have done the homework ahead of time. But in Islam, there is a form of a prenup that is traditional.
It's called a mahr, M-A-H-R, right?
Thank you. Yes. And it contains prenup type elements, and I've seen them be held to be binding. And there is usually, depending on what is there and how they're signed, courts might recognize them as legal binding documents as prenups in our state. So
right. Although your mileage may vary because of the way your document is drafted. So not all they can go both ways, but it's not just an automatic no that this is not a prenup.
If you have if you have one of those documents, by all means, show it to your, if you're getting divorced, show it to your divorce
Mhm.
attorney. It may well be binding. It's important for your lawyer to be aware of that. So we
Right.
wanted to mention that because we've encountered cases where those are involved, and I've seen some that were binding. So
Mhm.
like you said, your mileage may vary. So, okay, let's go on. The next thing is this one's interesting. So this is uh, this is interesting because of who's involved. So, and also legally, want to talk about this. So, the headline is "Son of Virginia Bowling Billionaire." That gets your attention. Wins bid to seal bitter divorce case after wife said he cheated with the nanny and dumped her on Christmas Day. Ouch. Okay, this story was in New York Post. Link will be in the notes. The son of a Virginia bowling billionaire is embroiled in a bitter divorce worth tens of millions. He won a bid to seal the divorce case ahead of a courthouse showdown with his estranged psychologist wife. So that was published August 19th. So the court action must be like this week or coming up. So what's interesting is he won a motion to get the entire divorce case sealed, going back to when he first filed his divorce petition in January. And we're going to talk about sealing court files and court records because it's relevant here and it's interesting. So that means that the court papers in the case will not be accessible to the public. Now, the irony here is, of course, the information's already out there, and here it is in this story, including Kara's accusations that Peter dumped her on Christmas Day 2023 as she held their 4-month-old baby, and his papers admitting to having an affair with their former nanny, Annette Lombard. The estranged couple are both slated to face each other August 27th, almost been yesterday, in a hearing that's slated to be open to the public. So we don't know the scoop on that yet.
Mhm.
But this guy's father is entrepreneur William Goodwin. And there's allegations in the case about adultery with the nanny and things of that nature. And I won't go into all the details, but eventually this nanny ended up getting employed by the husband in like the family company. So that's probably not cool. These are my opinions only.
Uh-huh.
So there was some text exchanges that were repeated in the pleadings. It's definitely a bitter divorce. So what's interesting, and I'm going to get to oh yeah, by the way, the father owns the AMF bowling chain. So that's a monster. You know, they own like all those bowling alleys all over the place. So the gist, though, here's the important thing. Sealing court records means you're making the records private. The public can't access the court file. And Rahul, let's talk a little bit about how rare that is. Can you talk about how it is in Illinois and describe for the audience like what it means to seal a court record and how records are normally public, things like that?
Yeah. So typically, a court proceeding is of public record, like you said. So while you might not be able to search for it online, although there are some websites now that just sort of go and farm these things out and mine this data out, but typically, if you just a random person in the public walked into a courthouse and walked up to and wanted to go up to a computer terminal, which is how they usually are set up, and go up and search someone's name, you can see most or all cases that might be associated with them for that county or that jurisdiction. Of course, it's not throughout the state because the state's carved up into different counties and each county keeps its own court records. So it's a public record and you can see everything that goes on. So for example, if you go up to a courthouse and type in your neighbor's name and your neighbor had gotten divorced and you heard about it, you could probably see all their divorce documents and stuff in there, to the extent that they were entered by the court. Now, some people will say, as you hear about it, I would like to seal my court records, like you said. Well, it's extremely unlikely and very difficult, and there's got to be some overwhelming public policy consideration for there to be any sort of reason a court record has to be sealed. Typically, the courts will say, "Sorry, too bad. This is a public record." So
Right.
yeah, people would typically file or motion the court up in order to ask for this record to be sealed and tell the judge why it's of grave importance, of why it's such a strong public policy consideration that the public should not be allowed to see this or consume it. And so then, If you meet that burden, a court will then quote unquote seal the records, which basically means if you type up someone's name, you will not be able to see anything that was filed. You'll see the case existed, but
Right.
you're not going to be able to see any of the underlying documents within that case. It'll say it was quote unquote impounded. So,
Yeah. So we, you know, it's
mhm,
this guy's clearly concerned that his public perception is poor, and he doesn't want his wife to keep filing, or, you know, pleadings that she files.
right.
I'm guessing he's more concerned about new stuff that she's filing, because the cat is already out of the bag on all these other allegations. You know, clearly the story has all this bad stuff allegedly that he did or was doing. It's already out there. So I'm not sure what he's hoping to gain by this. Courts don't like to seal records forever, and there is a strong preference to having records be public for a reason.
Mhm.
So it's, and the flip side is interesting, because we should always keep in mind in these cases, someday your children might pull these court records
Mhm.
and read them, and they will be able to access them for decades. So we should be very careful about the things that we say in pleadings. And there's sort of a right and a wrong way to put allegations into pleadings. You can be fairly generic or broad about your statements, and then leave out the juicy details, but still get the job done.
Yep.
And if you're trying to ultimately negotiate a settlement in a case, and most of these cases are settled, and you're trying not to raise the temperature in the case, and just increase what I call the eye poking, or like the Three Stooges slapping each other stuff, that's like a descent into chaos, then I really try to avoid the super caustic, juicy, or nasty allegations. And, you know, all they had to say in the pleading was there was an affair. Probably didn't, you know, our pleading rules allow pretty general statements. And I'm guessing the affair is relevant in that state's law. You know, in our state, it doesn't matter. But in that state, it must have some relevance, or it wouldn't be in the pleadings. But there's a way to approach it that's sort of the gentleman's way to do it, and then there's a nasty way to do it. And the nasty way to do it just makes everybody upset. It doesn't advance the ball at all, and it just causes more acrimony, in my opinion. So
Absolutely.
yeah, you
And
know,
we've done it where there are some certain times where you have to get, in the event you say, well, I want the judge to make sure they know this is happening regarding some abuse or this or that or the
right.
other, or some impropriety. We've even done things where you file the motion and then you set the factual allegations as an exhibit that you're incorporating by reference only, so it's not actually getting filed,
That's
but
right.
a judge will see it.
That's
So the
right.
motion will just say, "Hey, he did some bad stuff."
That's
Okay,
exactly
well, that's
right. And there's
mhm,
no reason. There are ways to avoid putting it in the record, and if you have a hearing, you know, a trial or whatever, then the testimony will come out about those facts, and the details will come out. But the
mhm,
transcripts, which is the typed up version of the testimony, will rarely be included in the public record,
right,
if ever. So that's where the juicy details have to come out in order to make your case. But there's really no need to throw bombs like that in pleadings unless you're really trying to just cause pain. And people should think about that before they lob grenades around like that. So
mhm.
just wanted to talk about a little bit of that background of this. It's interesting on multiple levels. Okay. Let's talk. So next, I want to talk about we always talk about legal topics. We have a couple of questions from the audience, and we've got a topic we want to discuss about retirement assets. So Rahul's going to explain, generally speaking, how retirement assets are dealt with and divided in divorce cases, because we get these questions all the time dealing with 401ks and pensions, things of that nature. So Rahul, can you explain for the viewers and listeners, number one, a couple of questions. One is, generally speaking, how are retirement plans divided? So defining the marital and non-marital portions of plans. Two, is it a tax-free transfer? 3, when we divide them, is there tax involved? 3, do we have to sell anything? The question we get a lot is, do I have to sell the stocks or sell the stuff in the retirement account? 4, is there some way to protect my pension from my spouse, which we get a lot too, like from police, military, teachers, they've really earned their pension and they say, well, is there some way to protect it? So let's go through that if you can.
Yeah,
We'll kind of go step by step.
absolutely. So as a general concept, in Illinois and many states where you have it's an equitable division state and not a community property state, money saved in retirement plans during a marriage is considered quote unquote marital property. And again, we're talking only from the framework of Illinois. Your mileage may vary, as we like to say. So in Illinois, money saved in a retirement plan is considered marital property. So that means whether it's a 401k from your employer, it's a traditional Roth IRA that you started, a pension, a portion earned during the marriage is subject to division. We're not going to get into the too much technicalities of how you're going to divide it. I want to talk conceptually in the framework.
Right.
So typically what happens is you have to think about it as bookends, right? So any contribution made before the marriage will be considered non-marital property. And then the money during the marriage is marital. And then the money after the divorce is again non-marital. So you have this middle portion that would be marital. And typically that is determined by the date of marriage until the date the judgment for divorce is entered, although the court does have some leeway in determining if that should be the end date or if it should be a different date sooner than that. So, but typically, though, more likely than not, it'll be the date the divorce judgment is entered. So
we're specifically talking Illinois because we're Illinois to Chicago divorce
absolutely,
lawyers. But
absolutely,
it's similar in all the other states.
Right. And so, and then you have growth. So sometimes people will argue, well, there's gains and losses on these retirements. Is that marital? It could be partly marital. It just depends on the arguments of things, the way the trading has happened, et cetera. For pensions, unlike a retirement, unlike a 401k, things get a little bit more complicated, or at least different, because you're not dividing a pot of money, really. What you're dividing is a stream of future benefits. So that's really another consideration there. So how do you divide this? It's not like you can go into an account and say, okay, I'm withdrawing half and I'm going to give it to you. Typically in Illinois, it's a straight 50% is what of the marital amount is what a court would order, because that's what the law says, unless the parties agree to a different amount or a different division. So that's sort of a straightforward, non-controversial topic. Sometimes based on other factors, sizable non-marital estate, things like that, a court may do a 55-45 split or something, but more likely than not, it's a 50-50 split. So then what do you do? Well, there's as they say. It's an order that is issued after the divorce and is really to tell the retirement plan administrator exactly how to split the account between the spouses without, like one of your questions was, triggering taxes or early withdrawal penalties.
That's
because
right.
Again, you're putting in pre-tax dollars into a 401k.
So can I stop you for a second? So
yeah.
This order goes to Charles Schwab, right? Or Fidelity. And then they use that to divide the account, right?
Exactly. The court would stamp it, the judge would sign it, and then you would send it to, like you said, Charles Schwab, Fidelity, whoever else, Principal, or whatever else, wherever else it goes. And then they will be mandated to follow what that order says. So very important practice pointer for attorneys listening here, and even for for people who are going through this. That's not something some random person can fill out on a form and submit. You're going to get into a lot of problems. There are attorneys who focus just on QDROs.
Yep.
It might be a couple bucks, but go to them, because you don't want to try and unravel and undo a lot of this, because that can become a giant mess. So you really want to know that you're doing it right the first time.
Yeah, there's a lot of detailed complexities here that, like Rahul's saying, and there's too much on the line. Most people have a lot of money in it's their biggest or second biggest asset next to their home. And you don't want mistakes here. So like Rahul said, it's well worth the I want to reiterate what he said because it's important. Well worth the investment to hire a lawyer who concentrates in, we call them quadros or retirement benefits, to make sure that your language in your settlement agreement is correct and that your quadro language is accurate.
Right. And these fall under federal ERISA laws. So it's sort of not just something with some bank account that someone's holding money. Oh, that's just my retirement account my companies have. I mean, that's a very simplistic sort of low-hanging fruit approach to take. It's really governed by a lot of federal law. So you have to do it correctly. And otherwise, like we were talking about here, you can trigger unintended consequences. The
Right.
division might not happen the way you wanted, etc. Now, you also have then on the other side a government, like you mentioned, a police or fire department pension, government public pensions in Illinois. They use some sort of qualified domestic relations order, but it's called a qualified Illinois domestic relations order, or QUILDRO, as they say.
Right.
It's the same concept, but it's tailored for state law and public retirement systems. Now, if you have an account like an IRA that's not governed by ERISA, you don't need a quadro.
Right.
So the divorce decree can direct a tax-free transfer of funds from one person or one spouse's IRA to the other.
You just fill out a form with the company or fill it out online. They say yes, and boom, it's done. It's like more like dividing
it's
a
like
bank
a rollover.
account, right?
Yep,
Yeah.
exactly. You're rolling it over into your own IRA. Now, if you say, hey, I want to take this out as cash, you're going to have a problem. You'll get taxes, penalties.
Penalties. And people also ask us this question, like, well, is there a penalty for early withdrawal? I need the money.
Yeah.
Well, you can. Normally there is 10%. Right. You pay tax at your ordinary tax rate plus 10% penalty. However, there are hardship exceptions.
Sure.
One of them is divorce. You have to be careful about that and make sure you're consulting with an attorney and an accountant about doing this the right way. But there are ways you might be able to get around the 10% penalty. And it has to be a certain amount of time following the divorce. It has to be incident to the divorce. Can't be like 3 years later and then you pull the money out and say it's for the divorce. So I don't remember the rules offhand. Consult with an accountant, CPA about this. But there may be a way you can get away from the early withdrawal penalty. Another recommendation on these retirement plans, if you need cash, a loan from the plan might work. Might be something that's better to do than pulling the money out, and you're avoiding the taxation. Right. Usually the interest rate is very reasonable and you're paying the money. The cool thing is you're putting the money back in the plan. So you're paying yourself back. You're the bank, and the interest goes into the plan too. So effectively it doesn't cost you anything.
It's like a free loan. Oh,
yeah. You're borrowing your own money and the interest is going right back in your pocket. So it can be a very good way to borrow money if you don't have a better way to do it. And the interest rate can be very reasonable. So that's an option. There are limits to how much you can borrow, but it might be an option for you. You'd have to check with your own provider for details.
Exactly.
So, the last thing is on that, we talked about you said it's not taxable. You don't have to sell the stocks. The investments. The one other thing I think is worth mentioning, people say, well, how is it divided? Meaning I want to pick, somebody will say, I want to cherry pick the stocks, right?
Sorry.
Can you explain that part where, like, kind of the wedding cake theory, that is what I call it? And maybe you should have me answer what, I'll say.
I was going to say, I'm not really sure what your wedding cake theory means, but
it's really layer cake. The way I visualize it, and then you can explain it, is slicing the cake where everybody gets half of the cake with all the layers.
Right. Exactly. So your 401k plan administrator will have picked funds to invest your money in. That's what they do. They invest money. So that's how you get the gains and, sometimes the losses. So two things on this, right? So you can't cherry pick, well, hey, I want to keep this fund, this, and that. Yeah. I want to give the other spouse all the losing funds. I don't want, and I want to keep all the winners. It doesn't work that way. Like you said, you're getting a slice, you're getting a cross section of what's there. You guys are going to split it right down the middle or whatever else proportion, and nobody gets to pick and choose, well, I want the little piece of chocolate here, I want the third layer, and I want the seventh layer. Nope. You're both getting all the layers and a proportion of that. And the other thing, as it relates to that, you have to be cognizant of is the valuation, right? So retirement accounts fluctuate with the market, especially these days. They fluctuate like crazy. One day it's down 10K, the other day it's up 25K, depending on how much you have, et cetera. So timing really does matter. So you have to be sure what value are you using. If you're going to lock in a valuation date, say, hey, I'm going to divide it as of December 2024. And so anything after that is going to be mine, whatever. That's great if it's going to go up. But if the market tanks and you have less than what you had in December, guess what? Now you're going to get that person will still get the dollar amount that they were supposed to get. And, it's sort of, you have to be very mindful because you want to know when you're valuing it at and how, if it's going to be valued in the past, make sure it's like a percentage and not a dollar amount, because dollar amounts can get you in trouble if you're betting on the market going up and it doesn't. So
that's really important. Thank you. The last point on this topic is, how do you, the question we get a lot is, well, especially from police and teachers, and it's understandable, it's to say, well, can I keep her from getting half? No.
Right.
Yeah, the short answer is
sorry. Short answer, 2 letters.
Yeah, it's an easy answer. Unfortunately, no. On the plus side, if you were working the job before you got married, that's going to be yours. That won't be split. And you work after the divorce, that goes in your pocket. So,
or you make a deal, right? You make a deal. You tell her she gets a lot more of a different asset in exchange for you keeping your pension. You can make a deal, but legally they get a slice if you can't make a deal.
Yeah, if you go to trial, they're just going to get their, let's call it their half of the marital portion, and that's it. There's nothing you can do about it. Yeah, and they don't get a pile of cash. They split your benefits. So essentially, they become a beneficiary. If it's a 401k, they do get, let's just say, half of the 401k, and it gets rolled over into their own IRA, like Rahul said. Yeah. If it's a pension, a future stream of benefits, like Rahul was talking about, they become a beneficiary like you. And you don't hand them the money. The state or whoever's the pension administrator sets them up as a beneficiary, and they just start getting checks. So your check gets smaller, and they start getting a check, and that's it. So, and they, by the way, they wait until you get paid. So they're like
half your. Sorry, go ahead.
They're riding along with you.
Right, and saying they get half your pension might also, if you want to cushion the blow a little bit, it's half of the marital portion of your pension. They're not going to get half your pension. Let's say you're 30 years in the force and you were married for 10 years out of the 30. Ostensibly, a third of your pension is marital, and they would get a half of a third. So they would get a sixth.
Yeah.
Right? Really is what they're going to get. Yeah. So, oh my God, they're going to get half my pension. Well, half of the marital portion. If your entire marriage was your,
right.
Then
in that scenario, you're talking about 16.5% of the pension. So it's not a huge, if somebody's been working a long time and married a medium amount of time, they're going to be splitting a modest portion of the pension with the former spouse. So we got a couple other good questions here from the audience. This one is modification of parenting. I'll explain the scenario. Here's the question. This is the exact quote. Divorce was done 1 year ago. Ex-spouse wants to modify one part of our parenting agreement we both agreed to at the time, not custody, but something less significant. So remember, custody is parental decision making. Visitation is parenting time or allocation of time. So who gets what time with the children? 2 different things. We don't want to mix them up. People cross the streams on this all the time, and it's not correct. There's also no full custody. That's a term I hear all the time. That's not right. Okay, so we will be going to mediation first, which is standard in our state. So in Chicago, Illinois, the courts send you to mediation on parenting disputes. The person that says, if we don't agree, we'll go to court. Do I, as the person who's supposed to be or is the respondent in this situation, need to file anything with the court if we do go to court that explains my position? Or does my ex file the motion and I simply explain my position in court to the judge? So Rahul, let's frame this. They have a dispute, and we know the standard parenting agreement says we must mediate first. They're going to go to a professional mediator, try to hash out this situation. Failing that, they're allowed to go to court and file a petition. So X will file a petition to modify. It doesn't even matter what the issue is. Let's just pretend it's parenting time. So they're trying to modify visitation, how much time they spend with the child. Should this person just show up in court and respond, or should they file a pleading responding to the petition filed by the ex to state their case in writing?
So I think this is not really. So I think this is a This is more of a nuanced practice question disguised as a parenting question, right?
That's
So
true.
not, because it doesn't really matter what the motion is being filed for. I think theoretically everything will be the same, whether it's for something related to finances, whatever. It doesn't matter. The question is, if my ex files a motion in court, should I respond or should I show up in court? And without getting too again nerdy into it, there is really there's a concept of a motion and there's a concept of a pleading. You know,
Yep.
you have to respond to a pleading. You don't have to respond to a motion. Now, there's a best practice element to this, which is if neither one of you say are represented by attorneys, and let's play this out. You go to mediation, not successful. Your ex files a motion in court. When he or she files a motion in court, he'll have to quote unquote give you notice of that motion, schedule a court date, and appear in court on that date to tell the judge, I filed this motion. At that time, the judge will ask you, do you want time to respond? To which you would say, yes, I want time to respond, or no, I don't want time to respond. Judge won't make a decision on the date he's presenting it, absent some sort of a quote unquote emergency. So let's say you tell the judge, yes, judge, I'd like a chance to respond because I'd like you to see what my position is. I don't want to, especially if I'm representing myself, fumble my way through court because it can be a stressful experience standing in front of a judge in an unknown, really unfamiliar area, trying to explain what's happening. So I would always say reduce your thoughts to writing.
Yes.
As a practice pointer. If it's a motion to modify something, you don't necessarily need to, you can just give the judge a narrative response if it's just a motion. If it's sort of if he's saying you violated a court order, then you should go line by line and respond to everything because he might want to hold you in contempt and you want to respond to every single allegation. But if he's just saying the pickup drop off isn't really working right now, it's not working for me, we can't agree to a different thing, I'd like to change the pickup drop off. Just write to the judge why you think it works or why you think it shouldn't be modified or what your position is. So the judge can just read it and say, this is what I think. Now, obviously, if you have a lawyer, your lawyer will respond.
They will do that for you. Right.
They'll do it for you. But this is presuming you're doing it by yourself. That would be our suggestion. And then you would file your response. And then you'd go back to court. The judge will say, have you filed your response? Okay. You should also send a copy of the response to the judge. And then at that time, the judge will decide next steps. Is it going to be set a hearing date so the judge can formally, quote unquote, make a decision? Or is it something that the judge will refer out to a guardian ad litem or whatever the case is? So then it sort of just branches out.
Yeah, an important practice note for those of you representing yourselves: if you're required to follow the rules lawyers are required to follow. There's no training wheels for self-represented people, what we used to call pro se, people representing themselves. The court requires everyone to adhere to the rules of practice, as Code of Civil Procedure, and their local court rules. So you've got to educate yourself on this. And this is where the DIY stuff gets sticky, because I tell people, they say, well, can I do it myself? The answer is sure. Just like you could do your own bathroom remodel, but do you know electrical? Do you know plumbing?
Mm-hmm.
Did you get a permit? Are you, when you tear everything out, is it going to take you 4 times as long as the guy who's a professional? And if you screw it up and you burn your house down or you flood your house, who are you going to go to? Right. So it's one of those things. You definitely can do some of this stuff yourself. The simpler things, sure. But as much as lawyers get a bad rap, for what the value you're getting in a lot of these things, it's your children, it's your future, it's your finances, your home, and your retirement. It's a very small cost to pay to get professional assistance. And there's a lot of benefit in that. So in any event, that's, I guess, my little advertisement for divorce attorneys. But it's just, if this is important enough to you, then it's worth making the investment. But let's steer back to the self-represented. Something like this post-decree, if it's a very simple issue, I mean, like a discrete issue, like Rahul's saying, like we want to change pickup drop-off, you probably don't need a lawyer, but you're going to need to follow the rules. And one rule that I wanted to mention, because Rahul said you're going to send a response to the judge, is there's a rule that says no ex parte communications. Well, what does that mean? You can't communicate with the judge directly. You can't send an email just to the judge with your arguments. They won't read it. They'll reject it. And you get in some trouble for it. You have to file it in a proper form, a response to that motion or that petition. You'd file it with the court clerk. And like Rahul said, copy goes to the judge, et cetera. And you have to give notice. You have to send a copy to the ex-spouse or their lawyer. And then that's how you communicate to the judge. You can't just call up the judge and talk to him or try to, like, a lot of self-represented people get very frustrated because they just want to start talking to the judge at the bench. So the bench is where the judge sits. And you'll step up on a status hearing and the self-represented person just wants to launch into how bad your client is. And they say, judge, I want to, I want child support and I want blah, blah, blah. And this X, Y, Z. And that's not the procedure. You don't just launch into your trial, essentially.
Right.
And we have, in our country, we believe in notice and an opportunity to be heard, meaning we have to
Due
give each other
process.
due process, right? So we have rules and you've got to follow those rules step by step till you get through the process. So that's what we're talking about here. So that's the answer, maybe a longer answer to this question, but I thought it was good because it had multi-facets that I think are interesting to touch on. And a lot of people are self-represented, and I understand it. That is going to get easier as technology improves and things like ChatGPT and other tools get better at legal. Right now, they're not good at legal. They're misquoting cases. They're making up, they're hallucinating cases. By the way, word to the wise for attorneys and self-represented people, generic AI tools are not ready for legal. Meaning ChatGPT, Grok, Gemini, they're getting close, but be very careful about statutory, meaning state law or federal law citations. So when you ask these things a query and it spits out legal information, it's very likely incorrect or not quite right. And it might look really good, but you have to go to original sources to check on them all and make sure that when they say a case, for example, says something, that it actually stands for that proposition, or when it quotes a statute, that law actually exists. Because lawyers have been getting in trouble and are still getting in trouble, big trouble with courts. I'm talking about lawyers for generating pleadings and stuff using AI tools, and it's completely wrong. So be advised. These tools aren't ready for that. They don't have a layer of legal reasoning baked into them at this time. There are private apps like Harvey and other ones that are starting to get there, and legal research apps like Lexis or Westlaw, but these public ones aren't ready. So heads up on that. Okay. Next item up for bids. Another question here, mediation. I'm in the information gathering stage. I'd like to go the route of mediation, but I'm learning you still need to hire attorneys. Do I need an attorney first, then go to mediation, or do we hire the lawyer after mediation is done? What's the point of mediation if you still need attorneys? And if you're amicable, can we share an attorney, or is that not recommended? I don't want to have to go and hire my own counsel and rack up a ton of attorney's fees. Rahul, what say you on this question of mediation with lawyers, without, et cetera?
It's a lot of questions and a lot of sort of this is very open and subject to interpretation. So I'll kind of unpack this as effectively and efficiently as I can. So the answer is, do I need an attorney first and then go to mediation, or do we hire an attorney after the mediation? Really depends. Depends on your situation. Some people say, hey, I'd like to have an attorney to bounce ideas off of while I'm in the mediation process, so I know whether or not I'm making the right decision during mediation. Right. You also have attorney assisted mediation, where both parties will attend mediation with their attorneys to further assist with the higher sort of legal aspect of mediation. Mediation, kind of stepping back, is where you have a neutral called a mediator who will help facilitate a discussion regarding all the outstanding issues between you and your spouse, if it's a divorce-related mediation,
right?
That needs to be resolved.
They're not the judge,
They're
right?
not the judge.
They're not deciding the case for you.
Nope. They cannot tell you you're right, you're wrong. They can say, hey, this is what he's suggesting, this is what she's suggesting. Sometimes mediators can say, from my experience, a judge will tend to do the XYZ a lot more than they would do ABC.
Right.
But there's no guarantees, etc. So they can't make a decision. They're not an arbitrator who will call balls and strikes. They
Right.
won't say you're right, you're wrong, this is how it is. So really it's just to help have a neutral there so one person doesn't feel like they're being strong armed by the other person.
Right. And
They,
they
mhm,
can't give legal advice. Another
nope.
critical thing. They
Hmm.
can't tell you you should do this, you should do this, avoid this. This is a good deal, this is a bad deal. Th- That's not what they're going to do.
Right, exactly. Because again, they're neutral. They can't give one person's. There's a conflict because one person's interest is different than the other person's interest, and they
Right.
can't give either one of you legal advice. So the question is, why do I even need a mediator? Well, you don't need a mediator. It's not a requirement unless you're trying to resolve parenting issues, in which case courts in Illinois mandate parties attend mediation first because it just does not want to decide what happens with your kids until you two have had a chance to work it out with someone neutral.
Yeah.
Now, that said, it's usually a much faster, more cost-effective way of doing it if you think that you and your wife can sit down, or I'm sure that you and your spouse can sit down and work things out.
Yeah.
Now,
Can I make a
mhm,
couple of
yeah,
points on
please.
this that
Hmm.
tie into what you're saying?
Yes.
Uh, so I find in my experience, mediators are very useful for discrete issues, things like parenting issues, clear cut things where we just need people to sit down and kind of hash it out.
Hmm.
If you're disagreeing on red light, I call it red light, green light because I used to do auto accidents in a past life. You know, if we're disagreeing on the facts, we're going to go nowhere in a mediation.
Right.
So if we're disagreeing that if you say your salary or your compensation is 100, well, let's say we're talking about maintenance, you know, alimony, and husband says his compensation is 150 grand a year, and wife thinks it's 250 grand a year. Well, we're not going to solve that in mediation. We're we're
No way.
locked into that's a factual dispute, and the referee is not the mediator.
Mm-mm.
So one of the prerequisites for mediation is agreeing on the basic facts. If you can agree on the basic facts and you're disagreeing on outcomes, the mediator can help with that. If
Right.
you're disagreeing on the facts, you're wasting a lot of time with a mediator. So, I mean, you might be
Right.
able to solve some issues where you agree on facts. There'll be other ones you don't, and you can push those off to resolve in another way. So, I find mediators can be very valuable in resolving parts of cases like the parenting stuff. But when things get sticky, it tends to fall apart because if there's a disagreement on facts, you're going to go nowhere in a negotiation if it's material, meaning it's big
Right.
enough, you
No,
know.
that's a great point. Yes.
So if it's small, if it's I disagree by 10 grand, a mediator could help you work out and come to a middle. That's one thing.
Hmm.
But
Right.
if it's
Exactly.
big, you know, if one person's alleging abuse of a child and the other person claims no such abuse has occurred, you're not going to mediate that away.
Right. Or
It's,
even I want custody or you want custody. No, I want custody. You can't. No, there's
yeah,
no way. It's
that
a
that's
clear
bind.
demarcation.
Yeah,
Yeah.
when it's binary like that, yes, no, on, off, you know, you're never going to
Mhm.
get that in mediation.
No.
This is where you are trying to reach a middle and you're already feel like you're going to get there. You have a pretty good feeling. So the reason lawyers are useful, like Rahul said, is they can give you the legal advice, they give you that guidance and prep you for the sessions, and they can debrief you. And also they can help prepare the documents to get the case done once the mediator creates the memorandum of understanding, which is the
Mhm.
document showing you what you've agreed to.
Right. Right.
So then the final point, what's the point of mediation if you still need lawyers? Well, mediation is still useful and the mediator is still valuable. It depends on how you want to use those lawyers to guide you. Now, my opinion is I would go collaborative because I kind of agree with this person. If you've got My question is, do you still need a mediator if you have two collaborative attorneys? So if you have two lawyers who play nice in the sandbox and understand mediation concepts and the parties are in the right mindset, I think the mediator is not necessary. I'd go the route of the collaborative lawyers because I think it's more efficient in my experience. So again, mediators, I think, super valuable in these very sort of clear cut issues like what days of the week do I want to take the child versus you? You know,
Right. Right. And the other sort of thing, just even a more simplified reason why do I need a lawyer is maybe you guys have a very small divorce, you went to a mediator and you said, "Hey, you know what? A mediator can't, like you said, they can only create a memorandum of understanding. They can't create your divorce documents for you." And just like you don't want to remodel your bathroom, maybe you don't want to create your own divorce documents. So
Right.
one person, you can both hire lawyers to, one can prepare the documents, with the agreement you've reached, and all the documents necessary for court, incorporating that, because you can't just take what a mediator prepared and hand it to the judge.
Right.
It has to be legal. You might have to file your case. You might have to then have a court appearance depending on the county you live in. So you might want a lawyer to do all that because you're too busy at work. You just don't want to do it. You don't have the
Yep.
wherewithal to kind of figure all of it out. So you might want to get a lawyer just for that component as well. And do you both need lawyers? No. But can one lawyer represent both of you? No. So one lawyer will be right. If you only want one lawyer, trust that person. Make sure you review everything. And I always tell people, don't try and save a couple bucks by chinsing out on it at this point. Get
Right.
someone to look it over. You're good. You don't need to, full boat on, I'm going to represent this guy in court. You could just get a lawyer to look everything over to say, "Hey, this is my deal. Does it say what it says?" Yes.
And you're already exactly, and you're already saving you're saving a ton of money in fees because you've worked
Right.
out most of it without attorneys involved every step. You're avoiding litigation. You're way ahead. So the few bucks it takes to have a lawyer look over everything is a bargain compared to the risk you're taking.
Mm-hmm.
So the one question here, just to put a bow on this, is the person says, if you're amicable, can we share an attorney, or is that not recommended? And you addressed it largely. But there's one other thing I want to mention that's a little different than mediation, and I call it the 1.5 attorney or kitchen table divorce. This kind of gets at what Rahul was saying. If you're really amicable, you don't even need a mediator. You're able to sit at the kitchen table and open up your laptop and just look at all your bank accounts and your 401ks and say, okay, you're going to get half. We're going to split this credit card in half. This is how my ex-wife and I got divorced. We literally opened up our laptops, went through everything. When we realized we were getting divorced, we just went through it all and said, okay, you take this, I'll take this. Here's how we're going to work this out. And we kept some notes, and then we prepared, we had the documents prepared, but, and, I was kind of my own lawyer, and one of the lawyers in my firm helped me. But then I recommended that my first wife go get an attorney who I respected, and referred her to that person. And she spent a few hours going over everything. We created the paperwork. My ex-wife trusted me to not pull a fast one. But even with that, I said, look, you've got to be smart, and let's make sure we hire somebody. And she was represented, went through all the documents to make sure it was what we thought it was. And she was cool with everything, and everything was signed. We got divorced, and it was super amicable, very quick, very efficient. So I say 1.5 attorney because one lawyer prepares this stuff, and the half attorney is the one who reviews it. It takes a lot less time.
Right.
So yeah, so that's an alternative to mediation. Is if you're really amicable, well, there's no reason why you can't hash things out at the kitchen table and just have lawyers write everything up and review it. So hope that answers the question. Appreciate those questions. Please keep them coming. That's from our Illinois Divorce Support Network. 1,500 members and growing on Facebook. Free to join, anonymous to post. Links in the show notes. Last, you got to tell us this one. This is great. Rahul found this dating app story. We love to tell you. We love talking about the dating app stories, and they never disappoint, Rahul, do they? Like every week, there's something new. We think we're out of ammo on this one, and then another dating app thing comes up that we've got to talk about. So, what's this one?
Yeah, absolutely. This is a GQ article that just came out, titled "Dating Apps Are Leaving 5'11" Men Behind." And so there's a lot of layers to this. Essentially, what the article says is men who are 5'11" face a lot of challenges on dating apps because of the height filters, where women typically set the minimum height requirement as 6 feet tall. So men who are almost 6 feet tall, let's say 5'11", get sort of filtered out. But also, this obsession with height has created a situation where men who are, let's say, actually 5'11", which I have my own theory on this, which I'll explain in a second, who are actually 5'11", are often perceived as less desirable, or they think that they're lying. So essentially, I have a running joke that basically I don't think anybody ever is 5'11". I think you're either 5'10" or 5'9", or you're 6 feet tall. I think 5'11" is a made up height because it's for someone who is actually 5'9" or 5'10", who wants to claim they're taller than they are, but they can't jump to the put a 6 in front of it. They're not. No one's gonna believe me if I tell someone I'm 6 feet tall. I'm like 5'10". So maybe on an app I would say I'm 5'11".
5'11".
I'm almost 6 feet, guys. I'm not 6 feet yet, but
Right.
I'm almost, because no one will believe me. But actually, so people who they're saying there are, I guess, people who are actually 5'11", who would have thunk it, who are getting filtered out or who are being accused of lying because they're not 6 feet tall. And you know what it describes is really, well, people who are it kind of goes through like certain different people's
Yeah.
dating stories and such. You
well-
can, we'll link it, but
Well, Rahul, isn't the problem too that we've talked about this before? The apps create this like car shopping thing where it's like, I'm going to dial a husband, like
yes.
I want a guy who's 6 feet, the old 6'5" in finance, that meme that was out like last year,
Oh yeah.
which they
Yes.
talk about in the article. And
Right.
there's this obsession among women that, I want to date a guy who's over 6 feet tall. And when you're setting these sliders on the search functions on these apps, it just makes it seem like I can just like dial a date, and if I put in
Mhm.
the machine what I want, this is
Like
what I
ordering a
get.
pizza.
And
Right.
yeah, and I want an 18-inch pizza, I want a 16-inch pizza, I want a 6-foot guy, right? So
Yeah.
they put the slider on there and they miss 5'11" guys, 5'10" guys that would look pretty much just like a 6-foot tall guy to them, but
Right.
they just like, I want a guy that's 6 feet tall. So it creates this real weird false division between
Mhm.
people over 6 feet and people under 6 feet. And I looked it up while you were talking real briefly. Guess
Yeah.
what the percentage of men is over 6 feet in the United States?
Oof. I don't know. It's
Just
what is
take
it?
a wild guess.
25%. 25%.
15. 15.
Wow.
15%.
So
For the record, I'm 6
100%
feet
of
tall.
women. You might be a little taller than 6 feet tall, frankly.
I think last time I went to the doctor was 6 feet, and I'll probably be
There you go.
shrinking soon. But this,
But yeah, so 15% of men are being vied by 100% of women, theoretically.
yeah. And we've talked about that before. We talked about the stats where they show on these dating apps, the lion's share of the women on the app select like 10% of the male profiles. Well, that jives with 15% are 6 feet tall, right? Just that one qualification. So it's
Right.
it's really interesting. So again, another vote for in real life dating, gentlemen. If you're trying to meet ladies, go out there and wear those platform shoes, and you'll meet the lady of your dreams. But the dating app creates this false sorting preference that doesn't exist in real
Right.
life, where your personality can come out and you're valued for
Mhm.
other things. So it's
Like, what did you say, right? What did you say earlier? You said short kings unite, right?
Short-
So
for the short kings out there, you got to meet people in real life. You're getting totally punished on the online dating scene wrongly.
IRL, as
So
you say.
IRL, yeah. So like this is interesting.
Exactly.
There's
So,
a single friend, this is a quote from the article, in her 30s, told me that on her preferred app, Hinge, she sets her height preferences to 5'11", not because she actually seeks out men who are at least that height, but she assumes I'll get men 5'10" and up, maybe even some 5'9" and a half as matches. Interesting. She's gaming the system.
well,
And
she
it's-
knows, because she knows people who are 5'9" and 5'10", like we talked about, say they're 5'11".
Yeah. And she said there's this thinking runs rampant as users get more disillusioned with the apps, and they're trying to game the system. So
Right.
it's,
Exactly.
there was one guy here earlier who said that he used to put on his profile that he was 5'13" as a joke.
Oh, yeah, that's
'cause
right.
he's actually 6'1". And he said once he set his height to 6 feet, to 6'1", his matches went way up, because nobody 5'13" wasn't getting like registered by the app.
Right. Exactly. Because again, they want to see that number 6. And it's sort of like they end the article by saying, when you order on the McDonald's app or whatever, you can
Yep.
have your Big Mac exactly how you want it to be, with extra mayo, light lettuce, etc. McCann says. So I think people love having all of their options and try to go for perfection on dating apps, when that's obviously just not how real life works. So
Yeah. Another interesting blurb here. Some older 5'11" guys remember height being less of a sticking point in the days before the apps. Yeah, I'm
Right.
sure that's true.
You're not walking around with one of those like AR goggles that tells you exactly how tall everything is when you walk by it. So,
Yeah. And the interesting
you
point
know,
this guy makes is more worldly than me. He says in parts of the world that use the metric system, the magic number is 180 centimeters, just under 5'10". So he goes,
right.
why is it a different number if it's such a big attraction for people? It's an arbitrary thing we just create in
Mhm.
the US. Pretty
Right.
interesting.
Exactly. So
So on
I
that
might not be
note,
6 feet tall, but I am 180 centimeters. So we're good.
yeah, you're good. You got to go in Europe then, I guess, man. You got to get out there or rest of the world.
Yeah.
Anyway, thanks. That's all we have for the show. But wanted to let you know where we can be found. Rahul, where can people reach you on social media?
You can reach me at Chicago Divorce on Instagram and on LinkedIn, just with my name.
How'd you get that handle? That's amazing. I'm
Yeah.
jealous. Good man.
Early,
Okay.
early mover.
Yeah, I'll say I'm at Rayford Palmer on TikTok, Instagram, Rayford Palmer on Twitter, and also on Facebook. And STG Divorce Law, our law firm in Chicago and serving the suburbs, also is available at stglawfirm.com. And I'm the author of the best-selling divorce book, I Just Want This Done: How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds. Available on Amazon, Kindle, Nook, Audible, and where all great ebooks are sold. Also soon to come out with the new book, I Just Want to Know. And that book is going to be about helping decide whether to get divorced. Much more on that to come. Very exciting. Hope to have it out by holiday, this coming holiday season. So I'm working on a book that's for the person that's not sure about getting divorced. So it's sort of a prequel. So much more to come on that. Exciting news. And we look forward to seeing you next week. And thank you very much for listening. As always, I'm Rayford Palmer, and that's Rahul Iyer. Take care. Thank you very much.
Thanks.